The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court.
Good afternoon and welcome to the North Carolina Court of Appeals. I'm Judge Valerie Zachary. Serving with me on this panel are Judge April Wood and Judge Darren Jackson. Assisting us today are Attorney Jean Soar with the Office of the Clerk of the Court of Appeals and Ziad Haq with the Supreme Court IT Department. We are live streaming this session of the Court of Appeals as we work remotely through the COVID-19 pandemic. Although we cannot currently invite members of the public to our courtroom in Raleigh, we are happy to welcome everyone to our virtual courtroom in the spirit of our tradition of publicly held proceedings. We have two cases on the calendar this afternoon before this panel. Both are from Guilford County. We have State v. Watson and Fox v. Johnson. We'll start with State v. Watson. If counsel are ready, let's proceed. Each of you will have 30 minutes for your argument, and of course, appellant will argue first. Mr. Casterline, you may proceed.
May it please the court, I'm Michael Casterline of Buncombe County. I am here on behalf of Shannon Watson. Mr. Watson was convicted of first-degree murder under the felony murder theory and acquitted on the predicate felony of statutory rape. We are asking the court today to vacate the murder conviction. I've brought forth two arguments in the brief. I'd like to address the first one initially and then move on to the second one. The first contention in our brief is that the predicate felony of statutory rape is not an appropriate or proper felony to serve as a predicate felony under the felony murder theory. This is based upon the holding of our state Supreme Court in State v. Jones, where the Supreme Court overturned a decision of this court and held that the predicate felony in a felony murder case cannot rest upon the culpable negligence intent standard, that it required a greater degree of intent to support a murder conviction. Now, the Jones court noted that it was looking beyond the plain language of the statute, noted that it was that the evidence would actually be sufficient to support the predicate felony in that case, which was assault with a deadly weapon inflicting serious injury, but that when you get to first-degree murder, you need to have either specific intent or the actual intent to commit the felony. Now, the problem that we have in this case is that the felony that the state relied upon as the predicate felony was statutory rape. Now, we'll talk for a moment about whether the idea of attempted statutory rape. But initially, I'd just like to say, and I think that the court needs to determine whether or not statutory rape can serve as a predicate felony. Or
well, Mr. Casterline, I have a question.
Yes.
Okay, there's no question but that rape would be a sufficient predicate felony, right? No. What do you contend distinguishes rape from statutory rape that makes statutory rape a strict liability offense?
Well, I think that there's a critical difference that rape, if we look at the offense of rape, is requiring a weapon or force or something to overcome the will of the victim. A statutory rape is a crime for another reason. It's because of the disparate power an adult versus a child, and the fact that the child can't give consent. There's nothing inherently dangerous about statutory rape. Statutory rape, the idea is that it's not about the consent, it's about the adult and the child engaging in vaginal intercourse, and there's nothing dangerous. But rape, first degree rape, forcible rape, might involve kidnapping, might involve a deadly weapon, or some degree of force. More like a robbery or one of the types of crimes that Jones talks about that's based upon an actual intent or malice or something dangerous. And the other key difference is that when we have statutory rape, we don't have any, what makes it like the crime at issue in Jones is that a jury doesn't have to find any degree of intent. It's not saying that somebody doesn't intend to have intercourse, it's that a jury doesn't have to find it, and the defendant can't defend and say, I didn't mean to do that.
I'm sorry, Mr. Castelline, I just have a question about that. Would there be any difference in your mind or in your argument if the child were younger than the child in this action of 11 years old?
Well, I think not if they were electing to use the statutory rape crime as the predicate felony. I think that the issue that Jones is grappling with is that when you don't have a jury make a finding, Jones speaks again and again about a showing and proof beyond a reasonable doubt. When you don't have a jury making a finding of intent in some level, you can't support a first-degree murder conviction. It's about what facts we require juries to find. And when Jones says we are not going to find murder based upon the implied idea of intent, that's what they're saying. And they say, you know, in those cases where we use robbery as a weapon, we have robbery with a dangerous weapon as the predicate felony. We have a jury finding that the person actually intended to rob somebody. We have a jury finding in an arson case that the person actually intended to do something. But we don't have that in statutory rape. We have statutory rape requires vaginal intercourse and a disparate age. And that's,
Intercourse occurred?
pardon me?
Doesn't the jury have to find that intercourse occurred?
Well, they would have to convict somebody of the crime, but the critical thing that makes it much like the offense at issue in Jones, and if you Jones gives some instructive hypotheticals about a PTA mother driving recklessly to a meeting or a contractor using too short of screws, is that there's nothing criminal about sex. What makes statutory rape a crime is the age disparity, whereas other rape, where it's got force, it's the force that makes it the crime. And that's the distinction. And so just as in Jones, there's nothing inherently criminal about driving. What makes it a crime that can be used for an assault with a deadly weapon is doing it in a careless and reckless manner. And so when the Supreme Court looked at the facts in Jones and said, that's a bridge too far, we are going to draw the line at felony murder prosecution where there's no jury determination of intent, that's what Jones is saying.
Well,
they say that again, I'm sorry.
Excuse me, you've conceded in your brief that attempted statutory rape has the requisite intent. Okay.
I believe that if the court in this case had given the elements of attempted statutory rape, and remember, attempt is not just a word. Attempt is a common law theory of crime that requires the specific intent to commit the substantive offense. And so when we have an attempted offense, we give an instruction. So if the judge in this case, if the state at the charge conference, which they didn't, if the state had asked the judge, we want to be instructed on attempt, and the judge had read the elements of attempt to the jury as part of the felony murder instruction, we would have a much more difficult case here. But they didn't. And now the state wants to contend in their brief that, well, attempted statutory rape can serve as the predicate felony. I would submit that it could if that had been submitted as one of the predicate felonies, but it was not in this case.
But doesn't statutory rape have the same intent as attempted statutory rape? There
has to be some intent to have the intercourse, but again, with statutory rape, the completed offense, the jury is not instructed on the element. And the jury doesn't have to find that. And what I've said is I think a close reading of Jones reveals that what the Jones court is concerned about is a jury making the finding of intent. And a jury doesn't have to find that with statutory rape. But if the jury was instructed on the elements of attempted statutory rape, they would have to make that finding.
Well, didn't the jury, was the jury instructed with, in accordance with the pattern jury instructions?
It was instructed, it was not instructed on the attempt offense. It was instructed with the pattern jury instruction for felony murder, and it was given the pattern jury instruction for statutory rape. But the state never requested, at the charge conference, the state never requested the instruction on the attempted offense. And if they had, then we would, and the jury might have found the attempt. They might not have found the attempt, but at the very least, they would have passed on the idea beyond a reasonable doubt, the words in Jones, used again and again in Jones, they would have made the determination. But they didn't do that in this case. They weren't given that. And it's just like in the Cunningham case, which was a felony murder case where the jury was instructed on one theory of felony murder, and the state wanted to switch at the appellate level to a different predicate felony. This court in Cunningham notes that, well, you can't, even if the evidence is there, you can't switch the felony now because the jury wasn't instructed on that.
Well, Mr. Casterline, excuse, I have a question. Didn't you concede in your brief that the jury seemed to have relied upon the offense of the attempted statutory rape in order to get the predicate felony?
Well, I think the jury was very interested in that, and that's why they maybe should have been instructed on that, but the state didn't request that instruction.
But your client wasn't charged with the attempt, was he?
He wasn't charged with the attempt, and in fact, the state concedes in their brief that it wouldn't have been appropriate to instruct the jury on that, even though they say the evidence would have supported the attempt. But what we have is a situation where attempt, again, is a theory of a crime that comes from common law that has elements. It's not just a word. It has elements. It has the jury finding that someone has the specific intent to commit the substantive crime.
So just so I understand your position isn't that he should have been charged with the predicate felony in order for him to be convicted of the felony murder?
The position is, if the state wants to rely upon the attempted statutory rape as the predicate felony, then it was incumbent on the state at the charge conference to request an instruction on that. They can't not instruct a jury on it and then come before the appellate court when a jury doesn't find something and say, well, we can just substitute one felony for the other because the evidence is there. That's what was happening in Cunningham.
Would that have been proper for them to ask for the charge on the attempted rape if your client wasn't charged with the attempt?
Well, I think it's GS 15170 says that based upon an indictment, somebody can be convicted of a lesser included or an attempt. And that's recognized in the law, and that's somewhat in the Signs case where the appellate argument was that you can't have the offense of attempted rape. This court said, well, you can have the offense of attempted rape, and in fact, the trial court had instructed using the attempt instruction, and that's why this court said that was permissible, because they did that, and it was the I think the dispositive fact in the Signs holding that the jury had been instructed consistent with the attempt instruction. This, we don't have that. We do not have a jury finding anything about the facts necessary to support an attempt conviction. All they get is, as part of the felony murder instruction, they get attempt as a word. They don't get the elements of attempt. And that's what is the problem in this case, is the state didn't request that instruction, and now the state comes in, and I think that they phrased the argument in this case that the attempt can be the sufficient predicate felony, and it I would concede it may well could be if it had been instructed to the jury and submitted to the jury that way. But without that, it's just like the in Cunningham, the state wants to switch the felony of breaking and entering to the lesser included breaking and entering, and this court says under the theory of actual breaking and entering, when such instruction is submitted to the jury, a defendant is not submitted to the jury, a defendant may not be convicted under a theory of constructive breaking and entering. And that's the state wanting to switch the theory without an instruction to the jury. And that's just what the state is seeking to do in this case, is they want to switch the theory. And I would submit that that's not appropriate, and that's especially not appropriate when we're talking about a felony murder case. And I think that in my analysis of it, the first thing I think the court needs to decide is whether or not statutory rape in and of itself can be the supporting predicate felony for a murder conviction under Jones. And I would say that it can't, because it lacks a jury determination of intent. It's not a dangerous felony. It's not the type of felony that would ordinarily support that. And the second thing I think is that we cannot accept the idea that the state can switch the theory at this point in time.
I have a couple questions.
Yes?
Okay, do you agree that the defendant need not be charged with the underlying felony?
Absolutely.
Okay, so you agree with that. And then do you think that when viewed in the light most favorable to the state, that there was sufficient evidence to support an attempted rape?
I think that there is evidence that would support that, and I am surprised the state didn't request that instruction.
Okay.
Since they immediately argue in their closing argument, they start talking about the attempt and the attempt and the attempt. And other than perhaps a shrewd strategy to deprive the defendant of the ability to say he didn't intend that, the question here is that the jury wasn't instructed on that theory, just as they weren't instructed on a lesser included in Cunningham, where they weren't instructed on the lesser breaking and entering, where they had abundant evidence that would have supported that. And this court said you can't switch your theory after you've instructed the jury on that. That's what they've done here. I think there is evidence of that. And again, in answer to the question, the felony doesn't have to be charged. And there are ample cases where the felony is not charged, but there aren't any cases that I could locate where the elements of the felony have not been given to the jury. And the elements of attempted statutory rape require a jury determination of specific intent to commit the substantive crime. And that's what we don't have here. We don't have a jury. We have evidence and we have verdicts, but we don't have a jury determination of the element. And Jones talks about elements. And when Jones is talking about elements, Jones is talking about things that are proven to a jury. And Jones says we're not going to find a murder conviction based upon implied intent, because a jury doesn't have to find anything but culpable negligence. The Supreme Court says that's a bridge too far. That's going too far with the felony murder. Jones would be different. This case would be different if a jury had to make a determination of actual intent.
Okay, so are you arguing that there's a fatal variance between the evidence at trial and the theory of felony murder on which the jury was instructed?
I think that the jury should not have been, my error, the way I've phrased the argument is the jury should not have been instructed on the theory of felony murder. The indictment isn't confined to a theory under first degree murder. We have short form indictment. is permissible. So the judge is not, the state's not confined to a theory when they start the trial.
Mhm.
The state asks for felony murder instruction, and they say we can support it with predicate felony of statutory rape. I think under Jones, that's inappropriate because it doesn't have the necessary element of intent.
Okay.
And just like statutory rape requires some intent to engage in intercourse, driving at issue in Jones requires some intent to get behind the wheel of a car. It's about the jury determination of the fact. And that's what Jones is concerned about. We're not going to predicate first degree, potentially capital sentences without some jury determination of a dangerous felony or intent, specific intent to kill. And the second issue I'd like to address for a few moments is that I've raised is I'll call it the incongruous or inconsistent verdict issue. And I just have a few comments to make about that. The reasoning of Mumford recognizes, or if that was extrapolated, there would be no problem with an inconsistent verdict. I would say, and my argument is simply that that's inappropriate to extend that reasoning into a felony murder conviction, because the relationship between the predicate felony and the murder conviction is very different, and the malice or the premeditation, the intent to kill, is based upon this fictional transfer of that element from the commission of the underlying felony to the murder case. So when you have an acquittal on the predicate felony, you have a situation where you don't have that necessary element of intent. Now, I would submit it would be a much more difficult case if the jury had been instructed on the elements of attempted statutory rape, i.e. the specific intent to participate in that crime, and then had acquitted on that offense. And then we would have what simply would be an inconsistent verdict. But we don't have that in this case. We have a situation where, on one hand, the state doesn't request an instruction on what they now contend is one of their predicate felonies, never goes to the jury never passes on that, and the jury does come back where they're given the elements of statutory rape, and they are unconvinced, they don't find it as proof beyond a reasonable doubt, and they acquit him on that. And without either that conviction or the elements of the predicate felony of attempted statutory rape going to the jury under the felony murder instruction, you have no finding at all by a jury of a specific intent to kill or an actual intent to participate in a felony. And so I think that we have something that the reasoning of Mumford would not support a first degree murder conviction. And with that, if there's no questions, I'll yield to the state at this time.
Judge Wood, do you have any further questions? Judge Jackson? Okay. Thank you, Mr. Castellan. Ms. Lawrence? Ms. Lawrence, I need to make clear, did you sign the brief, or did you?
Yes, Your Honor. The state personally signed the brief on March 2nd.
Okay, I'm sorry to bring that up now. It just occurred to me. All right, you may proceed.
Thank you, Your Honor. May it please the court. I am Sherry Lawrence, a Special Deputy Attorney General with the North Carolina Department of Justice, and I represent the state of North Carolina in this case. NCGS 14-17 sets out enumerated felonies that qualify as predicate felonies for felony murder. The legislature set out these enumerated felonies as any arson, rape or sex offense, robbery, kidnapping, or burglary. The legislature selected these enumerated felonies because they do contain the requisite intent for felony murder. The legislature did not exclude statutory rape from this listing of these 6 enumerated felonies. In fact, the language, look at the plain language of the statute, it states any rape or sex offense. The legislature also set out this catch-all category for other felonies to fall under. The legislature did not go through the work of specifically naming each felony. So these are unenumerated felonies that share the requirement of actual intent, and they have been qualified by case law. So they've been determined on a case-by-case basis. Statutory rape is rape. Under defendant's argument, he's asserting that these enumerated felonies, being that rape qualifies, statutory rape qualifies as rape, and the legislature has stated that any rape contains the requisite intent, and that's the idea of these enumerated felonies. The defendant is stating that these are invalid and that the legislature is wrong.
Excuse me.
Yes.
How do you respond to Mr. Casterline's citation of State v. Murray for the proposition that intent is not an element of statutory rape?
The response to that is that the intent is an element, it's inferred in the actual conduct itself. So the intent to engage in the actual sexual offense is the requisite intent that's required for purposes of felony murder. In addition, I think for forcible rape, the regular rape, I think the intent overall to engage in that conduct that's punishable by law is the requisite intent that's required. And in the case that the defendant relies on, State versus Jones, the court specifically stated that, again, the actual intent to kill, when talking about felony murder and how it differs from first-degree murder, where you do not have to find premeditation and deliberation for felony murder, it states the actual intent to kill may be present or absent. However, the actual intent to commit the underlying felony is requirement. This is not to imply that an accused must intend to break the law, but rather that he must be purposely resolved to participate in the conduct that comprises the criminal offense. So the conduct that comprises the criminal offense here for purposes of statutory rape is the vaginal intercourse with a victim, not an under. It doesn't necessarily just that victim. Strict liability applies to the element of age, as well as the defense of mistake of age and consent. So that would be our response to that contention, that there is an intent, there is a requisite intent. The legislature included it in 14-17 as an enumerated felony, and Jones actually talked about the difference between those enumerated felonies and unenumerated felonies and distinguished that there is a difference between them. And in doing so, the court stated that each of the 5 enumerated felonies requires that the perpetrator intends to commit the offense, meaning the offense within itself, there lies that intent within that offense itself. And if you look at the plain language, based upon the case law, being defendant's own case that he cites, Jones, they set out how burglary requires specific intent, rape, kidnapping, and robbery are general intent crimes. And the court, if you read Jones as a total, I think the court is getting at the point of saying that there's a difference between these two. These enumerated felonies have intent built in the felony itself. However, this catch-all, which was assault with a deadly weapon inflicting serious injury involved in Jones, is determined by case law on a case-by-case basis. In Jones, the court determined that culpable negligence was not proper. While it can be used to fulfill the intent for the actual assault, the felony assault, however, for purposes of felony murder, it was not proper. I don't think my reading of Jones, I didn't get from my reading of Jones that the jury must make a jury finding of intent. That specific language was not in Jones. However, when looking at felony murder and the felony murder rule, the felonies that are enumerated in 14-17, by the nature of those felonies themselves, the legislature has stated those felonies contain intent. So we're not in the catch-all section of 14-17, we're in the enumerated section. And looking again at the plain language of that, had the legislature intended to exclude statutory rape from any rape, I think they would have specifically stated that. However, it states any rape. So our contention would be that statutory rape does require a defendant to have the intent to engage in vaginal intercourse with the victim.
Are you contending that it's not possible to negligently commit statutory rape?
I think that would be the state's contention, just based upon the conduct that's required. There's no, just based upon the conduct that's required, I think that would be quite impossible to do. Just because one, as the defendant did concede, you have to intend to have vaginal intercourse just by the conduct and the act itself. However, as stated, the elements of age, the element of age, that's where the strict liability comes in, that the defendant is guilty, can be found guilty, as long as the jury makes a determination that this conduct, he had the intent to engage in this conduct of having vaginal intercourse with a victim. And in State versus Sines, this court's precedent, the court considered attempted sexual offense, statutory sexual offense, and they categorized that crime as strict liability. And this court stated that the categorization as a strict liability crime indicates that an individual may commit the crime of statutory sexual offense regardless of the defendant's mistake or lack of knowledge of the child's age. And it also means that consent is not an offense to the crime of statutory rape. This categorization as a strict liability offense does not alleviate the state of showing that the defendant intended to engage in vaginal, in this case, vaginal intercourse with the victim, which is the criminal conduct of the offense. So in Sines, this court considered sexual offense, statutory sexual offense, which is very similar to statutory rape, with the exception of the actual conduct that's covered. So in Sines, this court acknowledged that as applied to age and consent, it is a strict liability crime. And it does not alleviate a defendant from having to prove or having the intent to engage in that conduct. And here we would say that Sines is very important and is very instructive, because I think the same logic applies to this case, that it does not alleviate the state from having to show the defendant's intent to engage in vaginal intercourse. So that intent is there based upon State versus Sines, as well as the legislature not specifically excluding statutory rape from one of the enumerated felonies.
Excuse me, I want to skip ahead a little bit and just ask you if you're aware of any case in which the defendant was convicted of felony murder but acquitted of the underlying felony.
On my at first thought, no, Your Honor. However, I think my response to that will be that the state is not even required to even separately charge the defendant with any of the predicate felonies. In this case, it just so happened that the state did charge on that offense. And the state could have very well not have done so. In fact, the Supreme Court has stated that the better practice is not to do so. However, in this case, there is an acquittal for, I guess, the separately charged predicate felony. However, that does not negate or take away from the jury's guilty verdict for the felony murder, because the trial court, yes.
Let me ask you a question. Are you conceding that the predicate felony was the statutory rape, or are you saying that the predicate felony was an attempted statutory rape? What's the state's position?
Based upon the charge that the trial court gave to the jury, the trial court did state that they could find that he committed or attempted to engage in, to commit statutory rape. So we would contend, based upon the instructions, they were instructed on both, both statutory rape, the completed offense, and an attempt. In fact, the state did make that argument during their closing argument.
And I read that. So at this point, is your contention that the underlying predicate felony was either or that it was the attempt, or that it was the actual statutory rape?
That it was either or, Your Honor. That's the state's contention, that it could have been either or.
Thank you. Go ahead.
And there was sufficient evidence for both predicate felonies, the attempted statutory rape as well as the completed offense of statutory rape. There was more than, the state proved both of those more beyond a reasonable doubt based upon the evidence that he completed the rape after the murder and he attempted statutory rape prior to the murder of the deceased victim. And again, kind of moving on and getting back to the point that the state wasn't required to even charge on those. And I think we've kind of segued into argument 2, and I kind of go with that flow if there's no other questions on argument 1. So first off with argument 1, and I think as applied to argument 2 as well, the defendant appears to be bringing a sufficiency argument. I think it's kind of hard to follow defendant's argument and exactly what he is alleging. However, based upon it seems as if he's arguing sufficiency, which was not preserved at the trial before the trial court. And it cannot be under Rule 10, he had a duty to preserve it. However, he failed to do so. And this court should consider it waived and not reviewed for plain error. Even if the defendant had preserved the sufficiency challenge, there was sufficient evidence for both of the predicate felonies.
Excuse me, I want to go back to that, what you're talking about with the sufficiency challenge. Is sufficiency the only way to set forth defendant's claim here?
Well, in all due respect, it is defendant's, I guess. Defendant has the burden of setting forth his issues to the appellate court in an appropriate manner. I think in the manner in which it's set forth, I think defendant definitely does realize he failed to preserve these issues and is framing them in such a way as an unauthorized verdict under 1446, which we would contend it is a sufficiency argument because it seems as if he is attacking the sufficiency of the evidence for the underlying felony, predicate felony for felony murder. And in addition, it kind of seems like he's doing that for argument 1 as well. Because he failed to preserve those arguments. Because I think defendant did state just a little while ago that as to argument 1, that he was, that the felony murder theory should not have been sent to the jury ever at all, which I think that would be kind of like a sufficiency challenge as to both.
But didn't he concede that there was sufficient evidence when viewed in the light most favorable to the state of attempted rape? And I believe of statutory rape as well.
I know that he did concede the attempted rape, sufficient evidence. However, I do not recall the defendant specifically conceding the statutory rape, that there was sufficient evidence of that, not that specific contention. I think he kind of got at that point in his brief, which we can infer to be definitely a concession as to it. But I do not recall a specific statement stating that.
So would it still be a sufficiency argument if he's conceded that there was sufficient evidence on attempt and on a statutory rape? If he in fact concedes those two, does that take care of your sufficiency argument?
No, Your Honor, it does not, because I think the sufficiency argument applies to felony murder as in all, because without the predicate felony, as defendant states in his brief, there's no felony murder. So I think the defendant is directly, as he stated during his argument, directly attacking the sufficiency of the felony murder theory. Because the defendant did state that felony murder theory should not have ever been sent to the jury, which I think that directly attacks the sufficiency issue, which the defendant did not preserve and should be waived. The jury's acquittal of the separately charged offense of statutory rape is of no consequence, is not determinative to the validity of the felony murder guilty verdict based on both predicate felonies. The trial court instructed the jury on both. The jury was not required to unanimously agree to one felony, predicate felony, or the other predicate felony. The jury could have found one, or they could have found both predicate felonies to support their felony murder guilty verdict. The verdicts, while the jury acquitted on the separately charged statutory rape, it is inconsistent with a felony murder. However, it's not legally inconsistent. It's a mere inconsistency. And I would ask this court not to speculate as to why the jury did what they did. As State versus Mumford and Dunn and U.S. Supreme Court's Dunn and Powell set out that sometimes juries do things because of error. They do things because they reached a compromise. And here I would say that that is likely. However, I would ask this court to follow the U.S. Supreme Court's guidance here, not to speculate into the reasons behind a jury's verdict or their mere inconsistency in their verdict. The jury was charged for statutory rape as a predicate felony, was charged as a felony murder as well. So the jury found him guilty of those things. So we don't have a situation where he was acquitted of just statutory rape, but the elements weren't included for the statutory rape for felony murder theory.
Excuse me, I have another question on the sufficiency argument. How was this unpreserved in light of Golder?
Defendant's argument.
Because didn't defendant make the appropriate motion to dismiss or motions to dismiss?
No, Your Honor. I believe the defendant did not make the proper motions to dismiss in this case.
How so?
He failed to move to dismiss at the close of the state's evidence or the close of the state's of all evidence.
Don't you have longer than that? Don't you have, let me see, isn't there a statute that says you can wait until, even when the guilty verdict's coming in?
Well, that's not the facts that we have in this case. The defendant failed to make those motions.
Didn't make them at all, or didn't make them in a timely manner? Which are you arguing?
That he failed to make the motions.
Just didn't make them at all?
Yes, Your Honor, that would be the state's argument.
Okay, because my recollection was that they did, but we'll wait and let your friend here, Mr. Casterline, address that issue.
Based upon sufficiency of the evidence, he did not make those motions, and based upon the theory, based upon the arguments that he's now presenting on appeal, because I think the case law is clear that he does have to state the basis of the motion. So he did not argue the basis as now being argued on appeal. In fact, I think that's clear from the way the defendant framed his argument. He framed it under 1446 as being unauthorized verdicts for issue 2. And for issue 1, he framed it as an instructional error. For issue 1, the instructional error would be that it appears as if the defendant is contending that the instructional error is the attempt instruction. That's his contention.
Mm-hmm.
And again, as to argument 2, defendant's argument 2, Mumford, Dunn, and Powell, these are all cases that are very relevant here. There was a mere inconsistency in the verdicts. However, the defendant states that this court should not follow it. However, there isn't anything to preclude it. I think this is not the actual charge that's involved that should sway the court as to whether or not to apply Mumford, Dunn, or Powell. It's the actual principle that's being applied, which is the same, not to speculate as to why a jury did something or did not do something, especially when there is sufficient evidence for that charge. And there was sufficient evidence for that predicate felony and for the felony murder theory overall. The jury followed the trial court's instructions. The jury found the defendant guilty of felony murder. Both predicate felonies were valid under 14-17. And the trial court did not err or commit plain error. This court should affirm the defendant's convictions for committing the first-degree murder of the minor victim's mother while trying to attempt to rape her and later actually accomplishing his goal of raping her. If there are no other questions, the state will rest on its brief.
Well, I have a question. I know you're shocked, right?
Yes.
Well, how can we know that the jury properly considered attempt when the jury wasn't instructed on the three elements of attempt?
For the actual intent, the trial court instructed as for the jury the jury could find either that he committed it or he attempted to commit it. And those were the instructions that the trial court gave. And I think that kind of more goes to the defendant's actual argument about there has to be a specific word of saying intent. I think this court can take notice of the jury instructions for these enumerated felonies that the legislature have set out. And if looking at the pattern jury instructions for those, I think is the instructions all of them do not set out intent, that magic word intent, because the intent is inferred in the conduct. So that will be our response, and that will be our contention for that. If there are no further questions.
Any questions, Judge Wood? Any additional questions, Judge Jackson?
No, ma'am.
Okay. Thank you very much, Ms. Lawrence.
Thank you, Your Honor.
Mr. Casterline, you may proceed with your rebuttal. You have 8 minutes and 3 seconds.
Thank you. I guess the first thing I would just say is I think in our brief, this mentioned that the defendant's motions to dismiss at page 1844 of the transcript and renewed again at page 2014 of the transcript. And this was a defendant who proceeded pro se with standby counsel, but the motions were made, and I think they tracked the broad language that tries to include everything, every possible grounds. But I think the issue of sufficiency was preserved. I will say on the sufficiency issue, once again, I think that the state has got this idea about sufficiency to submit a case to the jury. There is clearly ample, sufficient evidence to submit this case to the jury on statutory rape or on attempted statutory rape. The question is, first of all, without an instruction on attempted statutory rape, can a jury find somebody guilty of felony murder using that as a predicate felony? And secondly, under my second argument, is when a jury, given sufficient evidence, acquits somebody, that is a jury finding that the evidence is insufficient to fully satisfy or entirely convince them of the facts. Just as in the Cunningham case, when the appellate court looked at the sufficiency of the evidence and said there's insufficient evidence of first-degree burglary, they vacate the burglary conviction and thereby have to vacate the felony murder conviction as well, even as the state tries to change the theory of felony murder at the appellate court. And here, they're basically doing the same thing where they're submitting a case to the jury. They have an opportunity at the charge conference. It's not the defendant who's waived an issue or not preserved it. It's the state that has waived or not preserved any argument that this was a valid predicate felony by not requesting a jury instruction on attempted statutory rape. And that's what they failed to do. And now they want to say that's the predicate felony. If they had given that instruction, the jury would have had to say, can we find that he had the specific intent to do that? And there was evidence they could have found it, but they didn't find it because they weren't given that element of a crime. Attempt is not just a word. Attempt has elements under North Carolina law, and this jury was not given those elements as part of their jury charge. And
Mr. Casterline, let me just ask one quick question so that I understand your contention. You say the jury should have been given the charge instructions on attempted statutory rape, although you concede he wasn't charged with that, and it would have been improper for the jury to have gotten those instructions?
What I'm contending is not that they should have been given those instructions. I'm contending that if the state of North Carolina wants to rely upon that as a predicate felony, the state should have requested those instructions and submitted them to the jury.
even though he wasn't charged
Well,
with that offense.
again, the state, there is the statute out there that says they could have requested that instruction. They say in their brief, the evidence would have supported that instruction, even though they also say it would have been inappropriate to give that instruction.
Do you
but-
say, would it have been inappropriate to give that instruction?
Well, there are cases out there that say that the evidence of the completed crime always necessarily includes the attempt. I don't know hypothetically if we would say that they should have given it. My client didn't ask for that instruction. The state didn't ask for it. And the error here is for the state to now claim that that's the predicate felony. And that's the state making an instructional error argument that they haven't preserved. They could have requested that instruction. I'm sure the prosecutor, the skilled prosecutor in a first-degree murder case, understands that by requesting that instruction, that gives the jury some additional elements they have to find. They didn't ask for that instruction. They can't switch horses now and ask for that to be considered the predicate felony. And that's what they're attempting to do here. And that's why we say just throwing the word attempt around is not the same thing as instructing the jury on the elements of attempt. Attempt is a crime. It has elements. And I would like to say again that, that it is not likely after doing several hundred appeals that I say that the statute doesn't mean what it says. But I kept running up against Jones where the Supreme Court looked beyond the plain language of the statute and said, well, the statute says this, we've got other theories that would support this idea, but that's just going too far. And one of the first things Ms. Lawrence said was, well, the intent can be inferred. And that is exactly what Jones speaks to. It says, conspicuously absent from our examination is any case where the intent is implied in a felony murder case. And that's the idea here, is that we're not going to let the intent element of a first-degree murder conviction just be implied or inferred. It's going to be found from a dangerous felony, use of a deadly weapon, or some fact like that. And we need to recall that the predicate felony in Jones was assault with a deadly weapon inflicting serious injury. Now, if someone beats somebody with a baseball bat to death, that could be a felony murder. But if someone is driving a car recklessly, Jones says that can't be a felony murder because the intent has to be inferred from the negligent operation of the motor vehicle, makes the motor vehicle a deadly weapon, thereby making the assault a felony assault, thereby leading into the Jones felony murder rule. Those leaps are where the Supreme Court said that's just too far. Similarly, we have that same problem here with statutory rape serving as the predicate felony. Attempted statutory rape, if the jury had been given the elements of that and passed on that, we would have a much more difficult case. We don't have that situation here. We have a situation where the jury was left with one predicate felony. The jury instruction is clear on that. Statutory rape, one predicate felony. They acquit on that felony, so we don't have that fictional transfer of malice from the commission of the predicate felony to the greater felony of murder. And they weren't given the elements of attempt or the other instruction. So the state's case is not, it fails. And we respectfully request that Mr. Watson's murder conviction be vacated. That's all. If anyone has questions.
Any further questions, Judge Wood? Any questions, Judge Jackson?
No, ma'am.
All right. Thank you very much, Mr. Casterline.
Thank you.
That concludes oral argument in this matter. I want to thank you, counsel, both for your excellent arguments today. And thank you for participating in our WebEx remote oral arguments. Good afternoon.
This session of the North Carolina Court of Appeals is adjourned.